Mr. Sims. As a little bit of background, I was appointed on Mr. Sims at the trial court level. I've followed this case up to here. I would like to reserve 5 minutes of time today.
Welcome, Mr. Bell.
Thank you, Your Honor. Your Honors, with regards to the matters before the court, we are here on one specific issue, whether or not the trial court properly applied the sentencing guidelines under various Tennessee statutes to Mr. Sims at his sentencing hearing.
What is the standard of review?
Your Honor, I appreciate the state's brief and clarification on that issue. With regards to the standard of review under 4035-401, I did simply read the statute and initially applied that standard. However, State v. Bis does indicate that it is a standard of review with regards to rather than de novo, that it is a abuse of discretion
Mr. Bell?
standard of review, Your Honor.
I haven't seen you before us. Are you new to us?
Your Honor, this is, I believe, my fourth argument before the Court of Appeals over the last 5 years.
All right.
I've been doing criminal work for about 14 years now, but this is only my fourth argument before the court.
Okay.
And some of the issues have been relatively self-contained.
I understand. That issue that Judge Greenholtz is talking about, that case is Buys, and Buys is a seminal case for sentencing
Yes, Your
for
Honor.
us. So we appreciate your concession on understanding what the appropriate standard of review is.
Thank you, Your Honor. And I would point out this is my first sentencing issue specifically to argue. Try to learn a little bit from each case.
Well, that's right. So does the standard of review, though, affect your argument? So I understand that we're here on an alternative sentencing issue.
Yes, Your Honor.
And so the Tennessee Supreme Court has applied the bias standard to alternative sentencing as well as to the length of sentences as well, has applied the abuse of discretion. But it's accompanied by a presumption of reasonableness. And the presumption of reasonableness comes from the, at least under bias, if the purposes and principles of sentencing are followed, and with respect to the length of the sentence, if the sentence is within the applicable sentencing range. Under caudal, it's the same thing. If the court is considering the purposes and principles of sentencing and is ordering a sentence that's available under law, then we have a presumption of reasonableness that attaches to it. And so the old standard of review, maybe you have some wiggle room here, but I'm wondering under the new standard of review under bias, after the 2005 amendments, doesn't that affect your argument pretty substantially?
Your Honor, it would. However, we also included the fact that the standard can be adjusted based on the sentencing court's failure to properly apply the sentencing guidelines if inadequate sentencing findings are placed on the record. We would suggest that that is what occurred here under State v. Carter and State v. Smith, which the state does concede could affect the standard of review here. We would
Carter's a 2008 case, right?
Yes, Your Honor.
And that's prior to bias. I think Carter's interpreting the pre-2000, I may be wrong, so don't hold me to it as it goes, but I think Carter's interpreting the pre-2005 amendments.
Your Honor, I believe it's correct, but I believe that the central holding is that the core issue at hand, whether proper information was placed on the record allowing for an appropriate review by the appellate court, is the core issue in Carter as well as Smith, a more recent case, 2024.
Sure, as well as in bias itself. Bias talks about that also.
Yes, Your Honor. And so I would argue that based on the lack of appropriate items placed on the record in this case, that this court can apply the de novo standard because the trial court did not appropriately review all of the sentencing factors and place them on the record in a way that could be appropriately reviewed. So under that theory, Your Honor, we would proceed under requesting a de novo review moving forward, and I would address the specific issues that were placed on the record or lack thereof to support that argument.
So bias says that the trial court is not, sentencing court is not under a particular obligation to place exhaustive findings on the record, simply enough for this court to be able to conduct meaningful appellate review. What is it that you contend the trial court should have placed on the record that impairs our ability to review the sentence?
Your Honor, specifically, there's a number of issues that were brought up during the sentencing hearing on the 29th of January that we would address. The court effectively only addressed, in our opinion, the issue of Mr. Sims' previous criminal history. That was the main issue that they looked at. That was the main problem that the court had with Mr. Sims.
Well, the court, I think the court also looked at the standpoint that he had gotten a pretty favorable plea agreement based on the fact that he was range 3 or maybe even higher, and he got a range 2, was allowed to plead in range 2 to an offense or to an amount of time that allowed him to petition.
Yes, Your Honor. The court addressed those two specific issues, and the reason why I'm kind of putting those together is because they are effectively all looking at his criminal history as the major sentencing factor. We understand that the court is allowed to distinguish between those, but the fact is that the only real piece of information that the court put on the record was that family, so to speak, of enhancement factors surrounding Mr. Sims' previous cases and his previous convictions.
Well, and you would agree that under the statute, he would not be considered a favorable candidate for probation based on the sheer number of convictions he has.
Your Honor, with regards to whether he's favorable or not, I think that there's a couple of issues to consider that the court did not consider with regards to those.
He's range 3, though, right?
Yes, Your Honor.
And so the statute says that range 3 defendants are not considered to be favorable candidates for probation.
And we would certainly concede that's what the statute directly states. But with regards to examination of the criminal record in and of itself, I think one of the things that the court did not properly review, was not placed on the record, was the length of time between most of these convictions and the current conviction at hand. We're talking over 30 years for the vast majority of these convictions, with one conviction of a felony nature in 2009, and the rest essentially being in 1990 or earlier. Also, those all occurred in other states, and so while there is a certified record, there's a little bit of lack of information as to exactly what occurred in some of those situations.
Does that challenge essentially go to the trial court's weighing of that evidence? And so if you have here some 25 prior convictions, and you say, well, maybe the trial court shouldn't have weighed it as much as it did because the convictions are remote, the convictions occurred out of state, other rationales. I mean, a disagreement with how the trial court is weighing a relevant sentencing factor doesn't typically undermine the presumption of reasonableness, does it?
The issue, Your Honor, is that we don't know how the court weighed it because the court did not comment on that specific issue. The length of time between the sentences was brought up at the argument as a mitigation factor. However, it was not addressed by the trial court with regards to whether or not the court was giving it any substantial weight or any weight at all. So this court is unable to determine whether or not the court gave it any weight, much less appropriate weight.
Looks like it gave it dispositive weight.
Yes, Your Honor. That's a fair point, but without placing the findings on the record, this court is hampered in its ability to test that specific issue, Your Honor. And so we would ask, again, under the de novo review, that this court review that specific set of issues, in addition to the other issues that were brought up with the trial court, specifically whether or not confinement is necessary. We understand that the court put on the record that he had previously been incarcerated. However, whether or not he's a continuing danger or not, I don't know if the court properly addressed whether or not he would continue to hurt other people, since this was an isolated incident, effectively after 30 years of criminal behavior, one isolated incident. I don't know if that meets the burden.
Was he still on the sex offender registry?
I'm sorry, Your Honor?
Was he still on the sex offender registry at the time?
Your Honor, my understanding was that he had been placed on the sex offender registry in Florida, and that there were significant issues with those bills at the time. The state never charged him with being on the sex offender registry. We had no issues with that at the time. I believe that he had been removed under the Florida rules, though it was difficult for me to get confirmation of that issue, given their issues with they have a number of appeals on that specific issue in the state of Florida.
Thank you, counsel.
I would like to also address, Your Honors, the state made an argument with regards to whether this issue had been waived due to the lack of inclusion of the plea colloquy taken on December 14th in the record. A couple of issues that I'd like to point out with that specific argument. First, the state relies on Ivy in that case, a case which itself is about the lack of the sentencing hearing being available at the Court of Criminal Appeals. We have the sentencing hearing here. At the plea colloquy, there were no actual issues of argument taken up.
Well, I think maybe, and I don't want to suggest what the state is arguing, but at least on the trial court bench, The plea colloquy is important because it has the stipulated facts. And so the state would announce what it believes the facts would show at trial. Typically, the trial judge either asks the defendant if there's a stipulation to it or if there's an objection to it. And so the facts of the case are established at the plea colloquy. Obviously, the facts of the case are incredibly important in sentencing, both as to the nature of the sentence, perhaps, to avoid depreciating the seriousness of the offense. Facts of the case are needed for that. So are the facts of the case in the record apart from the plea colloquy? Like, are they in the pre-sentence investigation report, or was there testimony here that established the facts of the case through the victim's testimony or otherwise?
Your Honor, the facts of the case are available in the record in a number of places. The first is the pre-sentence investigation does look at the facts of the case itself. The second is the
And
actual...
that's stipulated too, right? So a lot of times those are just the arrest records. Are you all stipulating that those statements are correct?
We are, Your Honor,
Okay.
and we also agreed to the inclusion of the pre-sentence report without objection at the sentencing hearing. So that was available to the judge at the time of the judgment, not just what was said at the plea colloquy, but specifically what was written in the pre-sentencing report, and that was a part of what we believe he reviewed in making his determination. There was also the fact that in the technical record, the records of the arrest are available. The state actually themselves did a good job of piecing together the issues in their argument, and we take no objection with their classification.
Why didn't you supplement the record simply with the guilty
Your Honor,
plea transcript?
I did request a copy of that. Unfortunately, I'm not exactly certain as to the status of it, but we did request a copy from the court recorder. Your Honor, focusing on a question that Your Honor asked earlier, what specific issues that the trial court failed to address is obviously the core of our argument if this argument were to go to a de novo review. We certainly understand that if it does not go to a de novo review, the issues, the burden for the state is much less to examine. The trial court, other than those specific issues with regards to my client's criminal history, did not address the other issues at hand. As we said, the length of time, did not address the certificates or other issues that were earned during his jail credit time prior to sentencing, did not address in a significant way his issues in terms of being able to reintegrate society with a commercial driver's license, his lack of mental health or drug abuse issues that would make him an amenable candidate to probation. All of those things were placed on the record. None of them were specifically referred to. Now, we understand that the court certainly doesn't have to use magic language, and we're not asking for that here. What we're simply stating is that the court did not acknowledge the mitigating factors in any real way. Given the lack of addressing those issues, we believe that the court failed to meet its burdens under the Tennessee sentencing guidelines, and we would ask this court to undertake a de novo review of the issues in supplementing the court's original judgment.
General Lord?
Make sure I don't touch the mute button. Good afternoon, Your Honors. May it please the court, Garrett Ward on behalf of the state of Tennessee. Your Honors, this court should affirm the trial court's manner of service determination with regard to Mr. Sims's sentence for aggravated assault because the trial court acted within the discretion granted it by buys, and this court shouldn't strip the sort of the buy standard of review from the trial court here because its findings on the record I contend are adequate. I'll start briefly by addressing the state's waiver contention. I don't think there's a ton of disagreement about sort of the nature of the facts in this case. There is some allusion to factually what happened regarding this offense. There is a warrant and an affidavit of complaint that certainly contains some recitation of what occurred. That recitation is largely repeated in the pre-sentence report. So there's certainly, it's not as if the state and the court are entirely in the dark here on appeal, but we don't have what really would be the best evidence of what occurred with regard to this offense. This was a conviction following a guilty plea. We don't have the plea colloquy, and we don't have the sort of the stipulated facts that typically accompany a plea colloquy. So
Do you agree with, I was going to say, do you agree with me? Do you agree with the proposition that the plea colloquy is principally relevant here at sentencing because of the stipulated facts?
I hesitate to paint with too broad a brush.
mean, in this case, it's principally relevant.
In this case, the plea colloquy is chiefly relevant because it would contain the sort of best recitation of what all of the parties agree the facts would have shown at trial.
So you heard your friend on the other side say essentially all of the facts are contained in the pre-sentence investigation report, and that he takes no issue with those facts.
To the extent my friend on the other side is willing to accept wholesale everything that's in the warrant pre-sentence report, because I believe they're the same recitation of facts, the state's comfortable with this court
That's fair.
Reviewing that. To the extent this court thinks it needs more, obviously I'd cede to the court on that point, but it seems that there's no serious complaint about the accuracy or anything contained in the officer's version contained in the affidavit of complaint and the pre-sentence investigation report. Turning then to sort of the meat of the issue, Your Honors, this is a relatively straightforward sentencing case. The trial court here, as I believe my friend on the other side concedes in his brief, the trial court here placed its reasons for imposing sentence on the record. I find that concession on the 9th page of opposing counsel's principal brief. The trial court does place its reasons on the record, so this concession makes sense. The trial court explicitly says that it is imposing this manner of service confinement because the defendant had 25 prior felony convictions as well as some misdemeanors. And the trial court is explicit about this as well, the trial court is imposing this formidable sentence of confinement because the defendant is already getting such a good deal in this plea agreement. There's no serious dispute that the defendant is being allowed to plead down a range that allows him to plead to a number of years that even gives him the possibility of probation. He's already getting a significant benefit from the leniency of this plea agreement. This court has said in a number of occasions, I cite, I think, the McIntosh case in my brief, because it also deals with a manner of service determination. But this court has repeatedly said that trial courts can look to favorable or lenient plea agreements and look to them as justification for imposing confinement. That's exactly what the trial court did here.
So your friend on the other side, I took it, the real gravamen of the argument here was that the trial court did not put on record that it had considered a lot of the mitigating proof. So certificates that he had obtained while in custody, evidence of rehabilitation, and that the trial court simply didn't mention that. And so our sentencing statutes typically require, not the use of magic language, of course, but typically require the trial court to at least talk about those other reasons. If, assuming, without deciding that the trial court ignored that evidence, would that have been proper?
So a couple of points on that.
I'm not saying the trial court did ignore it, but just on the, in fact, I'm not saying that at all, but on the face of the record, it doesn't look like those items were mentioned by the trial court. So if the trial court ignored it, that would not be proper, would it?
It would certainly not be ideal, Your Honor. I would, in sort of the platonic ideal of a sentencing hearing, the trial court does probably delineate specifically every mitigation factor raised by the defendant. In terms of does that remove the bystander review, I think our core inquiry is still, does the trial court put its reason for imposing sentence on the record? And this
consistent with the purposes and principles of sentencing, one of which is to encourage effective rehabilitation.
And if what the trial court says, which is, and I'll sort of summarize for the court what this trial court says, is that he can judge the defendant based on his record. He notes that there are some good things in his record. He doesn't explicitly say certificates and a large amount of time between your old convictions and this one, but he does say your good record helps you, your bad record hurts you. He specifically notes the bad parts of the record are the 25 plus convictions, notes that there's a favorable plea agreement. That is, in my view, the trial court placing its reasons on the record for imposing sentence and doing so in accordance with the purposes and principles of the Sentencing Act.
That's good. Thank you, counsel.
So given that, Your Honor, given what the trial court does say on the record, I think there is no basis for removing the bystander review, and under the bystander review, this sentence must surely be affirmed by this court, unless there are further questions.
Thank you, Mr. Ward. You had rebuttal time reserved, sir?
Yes, thank you, Your Honor. Just a couple of brief things. With regards to the waiver issue, Your Honors, I would point out that the purpose of the waiver is to indicate whether or not the Court of Appeals can make a proper determination from the record. And if you cannot, then waiver is appropriate. In this particular case, we would point out that all of the surrounding information allows the trial court to make, the Court of Appeals, I'm sorry, Your Honors, to make that determination. Specifically, State v. Dixon recently indicates that because the defendant admitted to the essential information contained in a pre-sentence report that was not included in the technical report, this court, the Court of Appeals, could go ahead with the review because that information had been admitted to and was available in other parts of the record. It's very similar to what we have going on here. Additionally, with regards to the trial court placing their findings on the record with regards to your good sentence helps you, your bad sentence hurts you, I would refer to page 11 of the transcript. Specifically, what is argued, what the judge says was, the only way I can judge those who come before me is by their record. Your good record helps you, your bad record hurts you, and yours is awful and you committed a violent felony. He's not making a reference to Mr. Sims' specific record. He's making a reference to anyone's record that comes before him. There's no specific reference to Mr. Sims' good record or things that were placed before the court at this time. Based on that lack of placement on the record, we are asking this court to undertake a de novo review at this time.
Thank you, counsel.
Thank you, Your Honors.
The case will be taken under advisement. Call the next case.
State of Tennessee